All right. So hello again. As I said, I'm Simon Stapleton. It's great to have you all here. So I'm healthy now today. What can I do to protect my retirement and other assets? And of course, if I'm married, from my spouse as well. And then on down to children or even grandchildren. Because I don't know about you folks, but most people that we talk to, they say, for example, I'd rather help a grandchild out with their education expenses than see the money go to a nursing home, right? You'd probably all agree. Yeah. Okay, so let's talk about how we can do that. Actually, before we talk about how to do it, I want to mention a couple of things that we don't recommend. So this is one of the things that we don't recommend, which is just an outright gift to a child. You know, somebody will say, oh, these Medicaid rules that Ben just went over, it all sounds so complicated. Doesn't matter the number, let's say I have 3,000 or 300,000 in savings. I'm just going to give those to my daughter to look after for me. What could go wrong, right? Well, some of the things that we do see, unfortunately, going wrong are up on the screen here. That child or grandchild they're too young to manage the money. They run into creditor problems themselves. So now it's not only their money that's exposed, it's the dad's money as well. His savings are exposed. What if the daughter gets divorced? Well, now the ex-son-in-law, now he says, I want half the marital assets. Oh, and you know that big gift that dad gave you? He's looking for that as well. So outright gifts, generally speaking, they should be avoided. And really, mostly because there's just a safer way of doing it, which I'll talk about in a moment. The other one that we need to be careful of is what we call traditional estate planning. So the I love you will, right? So go back to Ben's example of John and Agnes. So John's will says I leave everything to Agnes, but if she passes before me on down to the kids. Agnes, same thing. Her will says I leave everything to John, but if John's passed, on down to the kids. Well, that sounds simple enough. What's the problem? Well, the problem is that we don't know what situation we're going to be in when we pass. So going back to John and Agnes, let's say, unfortunately, this can happen. It was assumed John would pass first because he's sick in a nursing home, but actually, guess what happens? Agnes, she has a heart attack. She passes away before John does. Well, if they have wills like this, where does the money go? Agnes passes, it all goes to John, right? Where's John? He's in the nursing home. Well, that's bad news, because if he's receiving a government benefit, that's going to kick him off because he's just received half the money from Agnes. Or let's say he's a veteran, he wants to apply for the veterans benefits. Now he's not going to be able to for the same reason. He doesn't just have half the money, he has all the money now. Another way that we see plans fail frequently are these types of accounts. POD, anyone know what that stands for? Payable on death, okay? So we see bank account or brokerage accounts designations that either say POD, payable on death, or TOD, transfer on death, or in trust for. So many people come to us and they say, yeah, we're using POD accounts, so we don't have to worry about when we die. Everything passes payable on death to my son, my daughter, whomever it is. Well, that's fine as far as it goes, but what about if I have big expenses in a nursing home? That's not going to protect those monies, because the POD designation, as the name says, only kicks in on death. So if I'm looking to protect the assets from medical expenses before I die, we need to do something different than this. So if you choose to work with us, which we hope you all do, we want to make sure that we not only set up the right plan for you in the first place, but we also maintain the plan, so it's kept up to date as we go along. And the reason why I mention that is because AARP, they did a study, and they found that about 90% of estate plans fail because of this. They weren't kept up to date. You know, we see this all the time. People kind of, look down at the desk and they pull the old will out, blow the dust off it. It's 25 years old. And they say, oh yeah, this will, well, yeah, it's a bit old. The kids were in diapers when we did it, and now the kids are grown and they have their own children. So obviously your plan is going to look very different now to how it was 25 years ago. So we make sure it's kept up to date with our maintenance program. This is a very important slide right here, because Ben mentioned when I was working with Norman and Florence, I referred to myself back then as an estate planning attorney. So if you'd have come to see me then around 2000, I would have asked you this question up at the top here. What do you want to happen to your assets when you die? Now, of course, that's still a very important question, and we'll talk about that. But first, we, as elder law attorneys, we're going to ask you this question. Because statistically, this is a lot more likely that we become ill and we have this long-term care need along the way, especially if, as Ben was talking about, if that long-term care need is outside of the home, because we know that's where it gets really expensive. Oftentimes what that involves is we redo the planning. So we know chances are, if we're concerned about medical future, nursing home costs in the future, chances are just that I love you will is not going to help us. So we're going to build a new legal foundation for you, because what we do is we offer a free consultation, because you've been here today, and we invite folks to bring in with them their existing documents. But when we're talking about the legal foundation here, we're talking primarily about these documents on the screen. So 2 different types of powers of attorney, medical and financial, and then wills and trusts. I'll talk about both of those. We always recommend that you have both a financial and a healthcare power of attorney. Keep them separate. So again, using John and Agnes as our example here, John names Agnes as his agent and Agnes names John. And what that means is, if, let's say, they're traveling, they're in an accident, or for whatever reason, John is not able to sign himself, now with the power of attorney, Agnes can do that for him, write checks, pay bills. And later on, maybe he's lacking mental capacity, but they need to sell the house. Well, this allows Agnes to do big things too, like sign the deed to sell the house. Maybe they're downsizing. But they're younger now, they're traveling together, so they're going to name a secondary. We always recommend you name a secondary agent, a backup. So they've named Justin, their oldest son, as a backup agent for the financial power of attorney. Very important document. And of course, if you're single, that could be a niece, a nephew, brother, sister. There's lots of people to choose from. And then equally important, of course, on the healthcare side, is we've got the healthcare power of attorney itself. Same thing as the financial. Who do you want to make healthcare decisions for you if you're not able to do so? So John and Agnes have named each other. And then Katie, their daughter, she's a nurse, so they've named her as a secondary agent to make decisions if for some reason the other spouse cannot do it. A living will. So a living will is a document that deals with end-of-life decisions. So a lot of people say, for example, if I'm in a permanent coma, if the doctors say there's no chance of coming back, then I don't want to be kept alive by machines. Maybe for a few days, but not for weeks or months. But of course, that's your decision. You tell us what you want the living will to say. But what's really important is that you have it in writing. You don't want to put your family through that at a time when they're stressed out already. So that's the living will. Personal care plan, what do I want to happen medically if I can't speak for myself? And then lastly, the HIPAA release of medical records. That's the last medical document where you give permission to your family to have access to those records. So as I mentioned, wills and trusts. So question for you, if I have a will, does that will have to go through probate? Yes is the answer to that. A lot of people say no, but actually the will is the very definition of probate, meaning that the will has to be recorded with the court, and we have to go through this whole bureaucratic process, and as you see from the slide, it's a pain basically. It's pricey because there are court fees involved, often additional lawyers' fees. It's public because the will, just like a deed, is recorded at the court's house. Predatory for that reason, because anyone can go down to the court and see that information. And it postpones people's prosperity because the whole thing takes so long. It can take months, oftentimes a year or more, if there's real estate involved. So that's the bad news, but the good news about probate is that if we have a trust, then the trust completely avoids the whole probate process. But because of everything that we've been talking about today, we want to make sure that we have the right type of trust, one that's not going to cost us valuable Medicaid or veterans or other government benefits later on. So there are basically there are hundreds of different trusts, but they fall basically into three main categories. And the top two are the most important: a revocable living trust versus number two there, an asset protection trust. Got a little show and tell here for us. Here's our trust box. But before I talk any more about trust, there's one other legal rule that I want to mention to you, and that is called debtor-creditor law. Okay, so again, if we use John and Agnes as our example, let's say John passes away and this dollar represents his entire estate. Well, there's a couple of different things we can do. We can either give the dollar outright to Agnes, okay, but what debtor-creditor law says is if Agnes has full access to the dollar, so too then do her creditors. So Agnes says, no, I don't want that. I don't want the creditors getting to the dollar. So we say, okay, Agnes, here's what we'll do. We'll put the dollar in the trust. She says, well, wait a minute. I'm not sure I like that. We say, Agnes, it's okay, don't worry, because we're going to make you the trustee, the manager of the trust, meaning that you, Agnes, can go in and take the dollar out any time. Okay? But what did we just say about creditors? If Agnes can take the dollar out, who else can? Potentially a creditor, a nursing home, a big hospital bill, etc. So what I just described to you there is number one on the screen, the revocable living trust. And we refer that as the open box. Agnes says, no, don't want that. We say, okay, well, here's what we'll do. Agnes will turn the key, we'll close the lid, lock it up, and we will give you, Agnes, a co-trustee, a co-manager. And John and Agnes, when they set the trust up, they decided on Justin to be the co-manager when one of the spouses passed away. So now we're talking about number two on the screen here, the asset protection trust, which we call the close box. So let me give you a couple of examples now of how asset protection. First example, Agnes calls up Justin, co-trustee, one day, says, hey, I'm here, I'm stuck, my car's broken down, it's finally given up this time, we need to open up the trust, we need to buy me a new car. Okay, what does Justin say? He says, of course, Mum, it's your money, it's your trust. So they do that, they get the new car, Agnes is happy, she drives away in the new vehicle, we close up the trust again. Long time passes, now not such a happy conversation. Agnes calls Justin from the nursing home, says, hey, I'm here, I don't know if I'm ever going to be able to go home. Please, Justin, let's open up the trust and pay the nursing home. I've paid June, now it's July already. They're going to need to be paid for August, September, October. I don't know if I'm ever going to be able to go home. Let's use this trust money to pay the nursing home. What does Justin say? Justin says, no, Mum, remember, this is why you and Dad set up the trust in the first place. We're assuming we're pre-planning now, so the trust has been in existence at least 5 years. So Justin says if we need to, we can apply for Medicaid to pay the nursing home. But this money here in the closed box, this is for you, Mum. If there are things that Medicaid doesn't pay for, we can use that to take care of you. And also, Justin knows when John and Agnes set up the trust originally, they wanted to have a nest egg. They wanted to have money there to pass on down to the kids, to Justin and his brother and his sister, so the trust will allow them to do that. So again, that's number two, the asset protection trust, the closed box. First level of planning, if you will, the revocable trust is the open box. These are all things the revocable trust or any trust for that matter can do. Then next level up is the asset protection trust, the closed box. So sometimes if you research this, you'll see that referred to as a Medicaid trust. And while that is certainly true, it is good for Medicaid. Clients use it for lots of other reasons too. If you own a property or a house, someone comes into the house, falls down the stairs, gets injured, whatever. Now that person is not able to sue you because you are no longer the owner of the house legally. Now the trust owns the house. You have full access to it, you can do as you wish, but legally you're not the owner, so that prevents lawsuits against you personally. So we say this has all the advantages of the revocable trust, the closed box does, plus asset protection now while you're alive. So protection from creditors, lawsuits, and then after 5 years, we have protection from Medicaid and the nursing home, meaning, just as Ben described earlier, meaning these dollars, the home, whatever else is in the trust, Medicaid and the nursing home cannot get to that money. They cannot attach to those dollars. IRA inheritance trust, sometimes, rarely now, we use these to, if you have a large IRA, we might put those in a separate IRA trust because, of course, IRAs are taxed differently. So this means that beneficiaries' children take them seriously and understand the different tax consequences with the IRA trust. So those dollars are in a separate trust. So the best way to protect ourselves, care for our loved ones, is with this asset protection plan. Now, oftentimes, not always, but for many of our clients, that includes the asset protection trust, the closed box. So a question I often get when we talk about this is, well, do I still maintain control? And the answer to that is yes, absolutely you do. Because the house, because you're trustee of the trust, so the house, we're going to put the deed to the house into the trust, but it's still your house. So if you choose to sell it, if you choose to take a mortgage out, if you choose to sell and downsize, you can still do that. The only difference is you're wearing a different hat. Legally, you're selling the house as trustee of the trust. Same with the money here. Accounts are in the name of the trust, but you can take money in and out of those accounts just like you do now. Again, the difference is you're doing that as trustee of the trust. Good question. So the question was, what if one of the trustees is no longer mentally capable, mentally able to do this? Well, we have a couple of things to take care of that. The first one is a POA, a power of attorney. So the power of attorney you appoint ahead of time to say, I appoint my son or my daughter to make these decisions if I'm not able to do so. And oftentimes we include in the power of attorney that there needs to be a certification from one or two physicians saying I'm no longer capable of making these decisions. And we have that same provision in the trust as well. So let's say John and Agnes are trustees now. They can name Justin as a backup. If Justin's not available, then we go to Katie, then we go to their son Sam, and so on and so forth. So we can lay out those subsequent trustees. We lay all that out when we set the trust up. And we have a conversation with you, the client. What do you want these provisions to say? Are you okay with just handing off to Justin, or do you want a doctor to say that you're no longer capable? And we have that conversation and write the trust accordingly. Actually, before we talk about next steps, we like to be open up front here. So you might by now you may be saying, this all sounds great, but what's the first question you usually ask a lawyer? How much, right? It all sounds good, but what does it all cost? We say the cost of planning is about the same, or certainly no more than a month in a nursing home. So this is the range of plans from the most simple to the most complex. But this next bullet here, I would say this is the most typical package that clients choose. So our asset protection trust package is $6,500 for a couple, $5,500 for single folks. These are some other less common examples here, and I'll go over, as you see here, it includes will packages and deeds, so I'll go over with you what this all means. So the asset protection trust package includes, of course, the trust itself, the deed to your home, to any real estate that you own, as well as all the other documents that we've talked about today. So the last will, the general durable, financial power of attorney, medical power of attorney, the living will, and the HIPAA, the release of medical records. That's all included in the package. So I give an example here, and I stress this is just an example. So let's say it's a married couple. They choose the asset protection trust package, be $6,500. So that's 1% of their net estate, okay? Because $6,500 is 1% of this. So we say 1% to protect the other 99%. So guy said to me recently, well, you know, if I have more money than that, does that mean you charge more fees? No, the fee is the fee there. That is just an example there on the screen. Yes, sir, did you have a question? No, it doesn't mean that. So what it means is you say Medicare will pay for, Medicaid, thank you, will pay for a bed in a semi-private room, semi-private room. So what we can do is we can use the money in the trust to supplement that for a private room, for a different caregiver to come in, any of those things.
So you can't combine.
We can combine
Personal assets with the Medicaid.
Exactly. All right. Yes. Sure. Well, yeah, that's a great question, and a lot of families say, you know, we don't want mom or dad to go to the nursing home, and even if the parent stays at home, the money is still protected in the trust. Now, there are situations which unfortunately we see where the level of medical care that's needed becomes so high that it can only be done in a nursing home or a hospital-like setting. But, you know, if you're able to manage the parent at home, there are some Medicaid benefits that allow a medical aid to come into the home and take care of mum or dad there. So there are other options, but the key thing is that we want that money protected inside of the trust in case there is a high cost of caregiving later on. So yeah, these are all great questions. So thanks everyone for being here today and for all the questions. Go ahead and take your sheets to the back there when you're ready. And I'll be around, as I say, for a few minutes if you still have questions.